An employee notices something is wrong at work. Maybe it is unfair treatment. Maybe it is bullying. Maybe it is unpaid overtime that keeps getting ignored. They decide it is time to speak to HR. But here is the problem. What you do before that conversation can completely change what happens next. And in employment law, timing and preparation matter more than most people realize. So let's talk about what you should do before you speak to HR. First, understand this. HR is not a neutral advice service for employees. Their role is to manage risk for the business. Sometimes that aligns with helping you. Sometimes it does not. We recently advised an employee who raised concerns informally with HR about workload pressure. The issue was not properly documented by the employee beforehand. Later, the employer claimed there was no formal complaint made. That made everything harder to prove, which brings us to the first important step. Write everything down before you say anything. Not in anger, not in panic. Just a clear record of what has actually happened. Dates, events, conversations, emails. Who said what and when? Because memory fades, but written evidence does not. Next, ask yourself what outcome you actually want. This sounds simple, but it is often overlooked. Do you want things to improve at work? Are you looking for an apology? A change in behavior? Or are you already thinking about leaving? Because how you approach HR will depend heavily on your goal. Now, let's talk about evidence. If something serious is happening, like discrimination, harassment, or bullying, try to preserve any supporting evidence before raising the issue. That could include emails, messages, meeting invites, or even notes you make after conversations. But, just be careful not to breach confidentiality or company policy. The key here is to document, not escalate emotionally. Another important step is understanding your contract and company policies. Many employees go into HR meetings without knowing what the internal procedures actually say. That can weaken your position, especially if there are specific grievance or disciplinary processes that must be followed. We dealt with a case involving an employee who raised a complaint about unfair treatment but did not follow the company's grievance procedure correctly. The employer used that technicality to delay addressing the issue. It made the process longer and more frustrating than it needed to be. Now here is something many people do not think about. Once you speak to HR, your complaint becomes part of a formal record. That can be helpful if handled well, but it can also be used later in disciplinary processes or employment disputes. So clarity matters. Be calm. Be factual. Avoid emotional language in formal complaints where possible. Stick to what actually happened and how it affected you. Another key point is this. If your issue involves discrimination or serious misconduct, consider seeking advice before you speak to HR. Because the way you frame your concerns can influence how the employer responds. And sometimes, early legal advice can help you avoid mistakes that are very difficult to fix later. Finally, think about support. If you are feeling anxious about raising concerns, you do not have to go through it alone. You can ask to be accompanied in meetings, usually by a colleague or trade union representative. So what is the takeaway? Speaking to HR is not just a conversation. It is a step in a formal process that can have real consequences for your job and your rights. So prepare properly. Think clearly. Document everything. And do not rush. At Blackstone Solicitors, based in England, we help employees navigate workplace disputes, grievance processes and employment claims before things escalate further. Because what you do before you speak up can matter just as much as what you say.